Daniel Nolan and Sophie Nash. Sentencing remarks of Mr. Justice Spencer. Preston Crown Court. Friday the 14th of January 2022. Daniel Nolan and Sophie Nash, I have to sentence both of you for causing or allowing the death of your baby daughter, Ava, in August 2017 when she was only 8 days old, counts 5 and 6, and for causing or allowing her to suffer earlier serious injuries in her short life, brain damage and a fractured femur, counts 1 to 4. I also have to sentence both of you for an offense of child cruelty by willfully neglecting Ava in failing repeatedly to allow midwives into the house to see her, and a health visitor, count 7. You were convicted by the jury of these offenses after a 6-week trial, in which each of you sought to blame the other for causing Ava's injuries and ultimately her death. The prosecution made it clear from the outset that they could not say which of you was responsible for causing her injuries. For that reason, neither of you was charged with murder or manslaughter. Instead, you were each charged with causing or allowing her death and her earlier injuries. Parliament introduced this new offence in the Domestic Violence, Crime and Victims Act 2004 precisely to cover the situation in this case. And the jury were directed that they could convict you of these offences if they were sure either that you caused Ava's death and injuries or that you allowed Ava's death and injuries to be caused, even if they could not be sure which way round it was. In those circumstances, as guidance from the Court of Appeal makes clear, it is not permissible for me to second-guess the basis of the jury's verdicts when they have convicted both of you, that would undermine the very purpose of this unusual but very necessary statutory offence. The maximum sentence for causing or allowing a child's death is 14 years imprisonment. The maximum sentence for causing or allowing a child to suffer serious physical harm is 10 years imprisonment. Ava was born on the 8th of August 2017. She was your second child. She came home from hospital on Friday the 11th of August. I am quite sure on all the evidence that you were told before Ava left hospital that the midwife would be calling to see Ava at your home the next day, Saturday. On that Saturday, and again on Sunday and Monday, midwives called and knocked on your door in vain. They left calling cards and voicemail messages for you which went unanswered. Only when you were threatened with the intervention of the police did you allow a midwife into the house on the Tuesday, the 15th of August. From Sunday morning onwards until the night of Wednesday the 16th of August when the fatal brain damage was inflicted, the two of you were alone in the house with Ava. When the midwife called on the Tuesday morning and examined Ava, to all appearances she seemed fit and healthy. However, on the expert medical evidence she may well already have suffered by then her non-fatal brain damage and her fractured femur. The brain damage must have been caused by some form of violent shaking, with the unsupported head of this tiny baby moving rapidly to and fro. The fractured femur must have been caused by a violent pulling and twisting of the knee, probably during a nappy change. Whichever of you it was who caused those injuries must have known at the time that she had been seriously hurt, by her distressed crying or screaming. That reaction may, however, have been transient, with no physical signs of injury apparent. That would explain why the midwife found nothing amiss, if the injuries had by then already been caused. If the injuries were caused after the midwife's visit, as the consultant pediatrician Dr. Evans thought more likely, it must have been quite soon afterwards that Tuesday, based on the aging of those injuries by the expert medical witnesses. A summary of their findings which was placed before the jury will be appended to these sentencing remarks. The non-fatal brain damage is most likely to have been caused around midnight on the Monday, but could have been caused from midnight on the Sunday up to midnight on the Tuesday. The fractured femur is most likely to have been caused around 6 p.m. on the Monday but could have been caused from midnight on the Sunday up to noon on the Tuesday. There is no evidence that either of you left the house that Tuesday. Throughout that day Ava, in her Moses basket, was alongside the mattress in the downstairs sitting room which served as your makeshift double bed. Both of you would have been aware of any distressed crying or screaming by Ava. This was a small house. You both spent most of the day and night in that room. One of you caused these earlier injuries, the other must have been aware that Ava had been hurt. The injuries may have been caused in a single episode, or they may have been caused some time apart. It is impossible to say for sure, but Dr. Evans thought it more likely there were separate episodes, because it would be unusual to find this combination of injuries, brain damage and a broken femur, from a single episode of shaking. The more likely site of any fracture associated with shaking would be the baby's ribs, squeezed hard, but Ava's ribs were undamaged. There was also bruising to the back of her head inside the scalp, a bruise to her back over the spine, and a bruise to the surface of the brain itself, all of a similar age to the two principal earlier injuries. The fatal brain damage must have been caused late at night the following day, Wednesday the 16th of August. That afternoon another medical professional, a health visitor, had called at the house at about 4 p.m. She wanted to see your older daughter, aged 12 months, who was away from home staying with her grandparents at the time, but she also wanted to see your new baby, Ava. The health visitor knocked on the door in vain, leaving her calling card. You, Sophie Nash, left a voicemail message for her later that evening in which she said, quite falsely, that you had been out when she called. At 7 o'clock that Wednesday evening you were taken by surprise by the visit of a police officer, who had been detailed to call at the house to follow up concerns about possible domestic violence. It was an unwelcome visit which must have reopened resentment and arguments about what you both saw as unjustified interference by Sophie Nash's mother. It was she who had drawn to the attention of the midwife at hospital her concerns about the tensions and potential for violence in your relationship with each other. That police officer saw Ava in her Mosa's basket and heard her crying and whinging. She could not possibly have known that Ava had undoubtedly by then suffered that earlier brain damage and fractured femur. She accepted your insistence, Sophie Nash, that you were not the victim of domestic violence or controlling behavior on the part of Daniel Nolan. She left shortly before 7:25 p.m. It was at 11 p.m. that a 999 call was made reporting Ava's collapse. Only the two of you know what really happened in the lead-up to that 999 call. One thing is certain. Ava was shaken in some way by one of you, with sufficient force to cause her fatal brain injuries. She weighed only 6 pounds 10.5 ounces. She was only 8 days old. She was a defenseless baby. It was the duty of both of you to protect her. Instead she paid the ultimate price for that appalling breach of your duty as parents. She had only been in your sole care for a period of 4 days. In those 4 days you were responsible, between you, for allowing her to suffer brain damage by shaking, a fractured leg, and finally fatal brain damage by further shaking. All this took place against the background of a toxic volatile relationship between the two of you, which regularly erupted into violence. Selfishly, you were far more concerned with the day-to-day state of your relationship with each other than you were with the welfare and safety of your children. Each of you gave evidence for 3 days or more during the trial. The jury had an excellent opportunity to assess your personalities, as I did. Much of the trial was taken up with a minute examination of the volatile state of your relationship over the 21 months before Ava's death, quite literally blow by blow. As you each sought to portray the other as the more likely perpetrator of Ava's injuries. Yet even though each of you ran a cutthroat defense, asserting that the other must have been responsible for Ava's injuries and death, you stayed living together right up to the close of the prosecution case 3 weeks into the trial. Only when I imposed a bail condition that you should have no contact with each other did you finally separate. You had been planning to get married on the 6th anniversary of your first love-struck meeting. That anniversary was the 28th of November 2021, at the end of the first week of the trial. You informed friends on Facebook that regrettably it had been necessary to postpone the wedding because of some unfortunate events. In the poorest of taste, unthinkingly perhaps, but in my view revealingly, you chose to have your special night out together in Blackpool to mark Daniel Nolan's 16th birthday on August 2021, the 4th anniversary of Ava's death. All this demonstrates your selfish and obsessive preoccupation with each other which cost Ava her life. You both had a poor start in life. You, Daniel Nolan, suffered serious physical abuse at the hands of your father as a young child. You expressed to Sophie Nash your concern that you might become like your father. The psychological impact of that abuse has dogged your adult life. The jury heard evidence from a psychologist of the way in which such childhood trauma can have lasting negative effects: lack of self-worth and self-confidence, increased anxiety, susceptibility to bullying. On the other hand, and by contrast, it was you rather than your business partner who had the gift of the gab in calling customers in their homes for odd jobs. You had no difficulty in conducting online chats with 3 separate women, flirting with them only weeks before Sophie Nash was due to give birth. You claimed to have a phobia of traveling on motorways as the explanation for not being able to face the journey to hospital in the ambulance with Ava and her mother when Ava was dying. Yet you had made the 10-hour motorway journey by coach from Manchester to Portsmouth several times to visit and court Sophie Nash at the start of your relationship. You, Sophie Nash, have had to overcome serious disabilities. You suffer from cerebral palsy, the result of a stroke when you were born. It has left you with very limited use of your right arm, which severely hampered your ability to hold your babies and nurse them as you would have wished. At the age of 18 you were diagnosed with epilepsy, which interrupted your education and requires constant medication. You also suffer from autism, which affects your ability to process information and to engage entirely normally with people. It was for this reason that you had the assistance of an intermediary throughout the trial. I do not underestimate these difficulties. But you, Sophie Nash, are an intelligent and articulate young woman, much brighter intellectually than Daniel Nolan. In your early 20s you overcame your difficulties by succeeding in gaining a place at university, studying biomedical science. Your mother continued, very naturally, to be extremely protective of you, but by your second year at university you were enjoying increased independence and fulfillment. Then, in November 2015, you met Daniel Nolan on a dating website. He lived in Manchester. You were in Portsmouth. He swept you off your feet. You became pregnant almost immediately. You decided to move up to Manchester to live with him. You told your mother nothing of your plans or, initially, of your pregnancy. She only discovered where you were living when you were admitted to hospital in Manchester in June 2016 following a severe epileptic attack. She immediately drove up to Manchester from Hampshire to see you. You both lived with Daniel Nolan's mother and stepfather in Manchester for a while, then the two of you obtained a flat of your own nearby. You were living there when your first daughter was born in August 2016. Understandably you struggled as a new mother because of your disabilities. Daniel Nolan was your official carer, receiving state benefits as such. Even when you were living in Manchester your relationship was volatile and at times violent. There was an occasion in October 2016 when you, Sophie Nash, threatened to walk out, phoning your mother in Winchester in the early hours of the morning complaining that you were being kicked out into the street. She was sufficiently concerned to call the police. There was an incident at the home of Daniel Nolan's mother and stepfather, before your first daughter was born, when a violent argument ended in physical violence between you. Both of you had a short fuse. Your quick temper, Daniel Nolan, was shown in an unseemly argument with Sophie Nash's mother when the two of you took your first daughter down to see her in Winchester in November 2016. You, Sophie Nash, were left in no doubt about his Jekyll and Hyde character. In January 2017 you were telling Daniel Nolan in a Facebook message that you could both be nasty people to each other and sometimes took it out on your young first daughter, barely 5 months old. You, Daniel Nolan, have claimed that you saw Sophie Nash slap her on at least 2 occasions. She denies it. I make no finding about that. In March 2017, and now expecting a new baby, you decided to move to Nelson in Lancashire, far away from the support that Daniel Nolan's family had been able to provide in Manchester. It was a calamitous decision for both of you, for your first daughter, and ultimately for Ava when she was born. Your relationship soon deteriorated sharply, with ever-increasing violent arguments. As early as the 4th of April 2017 you, Sophie Nash, were texting your oldest friend in Winchester that you had got Daniel mad and he had put his hands around your neck. Your friend sent the text on to your mother, who called the police, unable to do anything else herself to help you from the other end of the country. That was a snapshot of your day-to-day relationship with Daniel Nolan. So was an occasion 24th of May 2017, when you were arguing so loudly inside the house that concerned neighbors, hearing it from the street, knocked on the door to check that you, Sophie Nash, were unhurt. You both pretended that all was well. Significantly, this was taking place in the presence of your first daughter, then aged 9 months. In Facebook messages you both acknowledged to each other that this was no way to carry on with a young child in the house. You, Sophie Nash, said that the fights and fallouts were unbearable and you brought out the worst in each other. All we do is wind each other up and upset one another. You said that you were destroying each other. You, Daniel Nolan, expressed concern that she was making me like my real dad, the father who abused you as a child and beat up your mother. You talked about splitting up, and you, Daniel Nolan, left home for 2 nights in June 2017, but in reality it was no more than a gesture looking for sympathy. The damage caused to the house is testament to the violence of your arguments. Fragments of glass embedded in the sitting room wall, from the throwing of an ashtray or a tumbler by one or other of you, with counter-accusations about that still being made during the trial, a mug of tea thrown by you, Sophie Nash, at a wall in your first daughter's bedroom in the course of an argument, thrown hard enough to leave a dent in the wall, and this when your older daughter was at your side, bedroom door. Panels kicked in by you, Daniel Nolan, during another violent argument. In your evidence before the jury you, Sophie Nash, eventually admitted in cross-examination that in the final weeks of your pregnancy with Ava there was violence between you during arguments almost every day. You would slap and kick him. He would slap you. It must have been a dreadful atmosphere for your first daughter when she was in the house with you, although she also spent a good deal of time away at her grandparents' home in Manchester, to ease the burden of childcare for the two of you. In hospital the day after Ava's birth, Sophie Nash's mother very properly alerted the midwife to her concerns about the state of your relationship, and its implications for your young family. You, Daniel Nolan, were so enraged by this interference that you lost your temper on the ward, biting back your anger as the midwife tried to mediate, having called security as a precaution. Sophie's mother was punished by not being allowed to take your first daughter with her back to Winchester for 2 weeks to spend some time with her family down there. Your first full day at home with Ava, Saturday the 12th of August, was a disaster. You had pressed on with plans for a party at the house to celebrate your daughter's first birthday. Your family, Daniel Nolan, came over for the day from Manchester. Your best friend, Sophie Nash, had come up from Winchester to be your birthing partner, and she and her mother were also at the party. You, Daniel Nolan, were suffering from a painful tooth abscess. You drank too much beer and brandy. To the astonishment and concern of your guests at this children's party, you dealt with excessive noise from your neighbor next door by going round and kicking at his door armed with a frying pan which you produced from behind your back to threaten him when he opened the door. Fortunately his partner dragged him back inside before there was any actual violence, but the police had to be called to calm the situation down. Later that afternoon, following an argument with Sophie, you were in such a temper and rage that you went outside and punched the shed to the further surprise and concern of your guests. You had lost it. That then was the way things stood at the start of Ava's first and last week of life. On the Saturday evening your family went back to Manchester, taking your older daughter with them at your request. Astonishingly you, Sophie Nash, told the jury in re-examination that you had even asked Daniel's mother to take Ava back to Manchester with them as well, only 4 days old and the day after she had come out of hospital. It was agreed that Ava would remain with you both at the house in Nelson, to give you an opportunity to bond with your new baby. On Sunday morning your friend from Winchester and her mother set off home. You were then alone in the house with Ava until her death 4 days later. On the Monday morning, August, there was another clearly evidenced demonstration of your violent temper, Daniel Nolan. Still in pain from the abscess, and frustrated by the burden of childcare and Sophie's inability to play her full part, you lost it again, smashing a pane of glass in the living room door whilst Ava was in the same room in her Moses basket, with Sophie alongside her. This was the background against which the two of you willfully neglected Ava by failing to allow the midwife into your home to see the baby on 3 successive days. You, Sophie Nash, say that you tried to get to the door but couldn't make it in time because of your disability. You say that you were too embarrassed to phone the midwife afterwards and give that explanation in response to her calling cards and voicemail messages. I reject that particular excuse without hesitation. The truth is that neither of you wanted health professionals in the house until you were forced to allow one in under threat of the police becoming involved. By the jury's verdicts, whichever one of you was not responsible for actually causing Ava's injuries was guilty of allowing her injuries and her death by failing to protect her, when the risk of injury to her from one or other of you in this violent household from a sudden loss of temper was or should have been perfectly obvious to you both. In sentencing you for these very serious offences, I am required to follow the relevant Sentencing Council guideline. In relation to causing or allowing Ava's death, counts 5 and 6, I am satisfied that for both of you this was a case of high culpability. 3 of the factors in the guideline are made out. First, the fatal brain damage Ava sustained from that final shaking shortly before she died was caused by the use of very significant force. The significance of the force used must be judged in the context of Ava's extreme vulnerability as a tiny baby only 8 days old. This injury would have caused her excruciating pain, hence the screaming you both described, but mercifully she would soon have become unconscious, never to wake up. Second, there was a deliberate disregard by both of you for Ava's welfare. Third, this was the culmination of multiple incidents of serious physical harm. The starting point under the guideline for a Category 1A offence is 9 years custody, with a range up to 14 years, the maximum for the offence. In relation to the earlier non-fatal brain damage, counts 1 and 2, it is impossible to say what the long-term consequences of that serious physical harm would have been, because Ava did not survive more than a day or 2 afterwards. I therefore treat it as Category 3 harm. The force used in this earlier shaking must have been less than the fatal shaking, but it was still the use of significant force. This was therefore a Category 3B offence under the guideline, with a starting point of 18 months custody. In relation to the fracture of the femur, counts 3 and 4, again this was Category 3 harm. In the light of the expert medical evidence, there must have been the use of very significant force in the context of a tiny baby aged only 8 days. This was a metaphyseal fracture at the lower end of the femur, just above the knee, where the growing bone joins the cartilage. The fracture experts gave evidence that the sort of force reported in the medical literature as required to cause such a fracture of the ankle would be the very considerable force used by a physiotherapist trying to force a child's club foot into proper alignment. This was therefore a Category 3A offence under the guideline with a starting point of 3 years custody. Under the guideline for child cruelty, the seriousness of the offence lies in the repeated failure or refusal to allow health professionals into the house. By the jury's verdict, that was willful neglect in a manner likely to cause Ava unnecessary suffering or injury to health. The starting point under the guideline for a Category 3B offence is a high-level community order with a range up to 12 months custody. In my judgment, this was a particularly serious offence of its kind because that repeated neglect was closely followed by serious injuries to Ava and ultimately her death. I cannot be sure on the evidence that the earlier brain damage and the fractured femur were not caused on the same occasion. However, in principle those offences and the offence of willful neglect merit consecutive sentences. The overall sentence I pass on each of you will therefore reflect the overall criminality of all your offences, but I shall pass the lead sentence on counts 5 and 6, causing or allowing Ava's death, with concurrent sentences for the other offences. I take into account the principle of totality. Neither of you has shown genuine remorse for these offenses. Remorse would have been demonstrated by early admissions of guilt when you were interviewed by the police back in 2017, and by guilty pleas to these charges. The thorough investigation of the case, and the need to obtain reports from a large number of experts has contributed to the regrettable delay. For 3 years after April 2018 you were released under investigation and no longer subject to bail conditions. You set about carrying on your life together. It was only when the summonses were served in March 2021 that things changed. I turn to mitigating factors and your individual circumstances. Daniel Nolan. You, Daniel Nolan, are now 30 years old. You were 26 when Ava died. You have some comparatively minor previous convictions, but they were a long time ago and I disregard them save to acknowledge that you cannot put yourself forward as a man of good character. I bear in mind the evidence given at trial on your behalf by the psychologist, Dr. Wood, and the content of his reports. I accept that you still suffer from the impact of the serious physical abuse you suffered as a young child. Dr. Wood spoke of your emotional vulnerability, anxiety, lack of self-worth and suggestibility, and of your compliant personality. That has to be balanced against the impression I formed of you during the trial, and the way in which you conducted yourself when you and Sophie Nash were finally served with the summonses for these offences in March 2021. I am quite satisfied that 2 days later, when she was very drunk, you deliberately set out to trap her into saying incriminating things about Ava's death. You do not lack guile. In my judgment, your psychological difficulties do not significantly reduce your culpability for any of these offences. You are well aware of the deterioration in your relationship with Sophie Nash, and of your increasing loss of temper and tendency to violence which put Ava at risk. You are equally aware of her capacity for violent outbursts. You are her carer and claiming a carer's allowance. Nor is there any significant mitigation in the circumstances of your relationship with Sophie Nash. You were as bad as each other. You each gave as good as you got. The conditions in Nelson were extremely poor, but you did little if anything to improve them, and despite the distance from Manchester, your mother and stepfather were still providing a great deal of support for your first daughter, relieving the pressure on you. I accept that your time in prison is likely to be particularly difficult in view of your psychological issues, and I bear that in mind. Taking into account all the aggravating and mitigating factors in your case, and all the submissions made on your behalf, your total sentence is 10 years imprisonment. That reflects the criminality of all your offences, and that is the sentence I pass on count 5, causing or allowing Ava's death. On count 1, causing or allowing the earlier brain damage, there will be a concurrent sentence of 18 months imprisonment. On count 3, causing or allowing the fractured femur, there will be a concurrent sentence of 3 years imprisonment. On count 7, child cruelty by willful neglect, there will be a concurrent sentence of 12 months imprisonment. Daniel Nolan, for these serious offences I sentence you to a total of 10 years imprisonment, made up as I have just indicated. Under current statutory provisions you will serve half that sentence in prison. When you are released you will remain on licence for the remainder of the sentence. If you breach the terms of your licence or commit any further offence you can expect to be returned to prison to serve the remainder of your sentence. I direct that copies of Dr. Wood's reports must be provided to the prison authorities as soon as possible, and I rely upon your legal team to facilitate that. Sophie Nash, you are now 31 years old. You were 27 when Ava died. You have no previous convictions. I bear firmly in mind your 3 separate disabilities, your cerebral palsy, your epilepsy and your autism. The combination of these disabilities made life much more difficult for you as a mother of young babies. I have considered the Sentencing Council guideline in relation to sentencing offenders with mental disorders. In my judgment, your disabilities do not significantly reduce your culpability for these offences. As I have already said in sentencing Daniel Nolan, you and he were as bad as each other. You gave as good as you got. You were well aware of the serious deterioration in your relationship as the violent arguments got worse. You knew the risk this was likely to cause to your children. I bear in mind that your time in prison is likely to be more difficult because of your disabilities. I bear in mind that having been led to believe that you could never have children, you have now lost both of them, one dead, the other given up for adoption. For you that must be particularly hard to bear. It is unlikely that you will ever be permitted to care for a child of your own again. Taking into account all the aggravating and mitigating factors in your case, and all the submissions made on your behalf, your total sentence is 8 years imprisonment. That reflects the criminality of all your offences, and that is the sentence I pass on count 6, causing or allowing Ava's death. On count 2, causing or allowing the earlier brain damage, there will be a concurrent sentence of 18 months imprisonment. On count 4, causing or allowing the fractured femur, there will be concurrent sentence of 3 years imprisonment. On count 7, child cruelty by willful neglect, there will be a concurrent sentence of 12 months imprisonment. Sophie Nash, I sentence you to a total of 8 years imprisonment, made up as I have just indicated. Under current statutory provisions you will serve half that sentence in prison. When you are released you will remain on license for the remainder of the sentence. If you breach the terms of your license or commit any further offense you can expect to be returned to prison to serve the remainder of your sentence. Thanks for watching. Please like, comment and subscribe.